If you've been injured in an accident in Virginia and you filed a claim or you're about to, the insurance company is already looking for reasons to deny it or pay you as little as possible. In this video, I'm going to show you the exact things that insurance companies look for to deny or devalue your injury claim in Virginia, so you can avoid the traps before it's too late. Hi, I'm attorney Sharif Gray. Our law firm represents people across Virginia who've been injured through no fault of their own. We prepare every case as if it's going to trial, and we've helped our clients recover millions of dollars after serious crashes and life-changing injuries. If you or someone that you love has been hurt, contact us today at 804-494-6908. We're ready to fight for you. Let's start with the number one thing insurance companies look for, and that's the gap in your medical treatment. This is probably the single biggest weapon that they use against injured people. If there's a gap between the date of your accident and the first time that you saw a doctor, they'll use that against you. If you waited a week before going in, they'll argue that if your injuries were really that serious, you would have gone to the hospital right away. And it doesn't stop there. If you started treatment, but then missed appointments or stopped going before your doctor released you, they'll say that if you are still in pain, you wouldn't have skipped those visits. Now, people delay treatment for all kinds of reasons. Some people are in shock and just don't realize how badly they're hurt until days later. Some people just can't afford to take time off work. But the insurance company doesn't care about any of that. All they see is a gap in your records, and they will use it to argue that your injuries weren't caused by the accident or just weren't serious enough. So if you've been in an accident, get medical attention as soon as you possibly can and follow through on every appointment your doctor recommends. Your medical records truly are the backbone of your claim. Now, even if your medical records are solid, the insurance company has other ways to attack your claim. Two of the most common are recorded statements and social media. Shortly after your accident, an adjuster may call and ask you to give a recorded statement. They'll tell you that it's standard procedure, but the questions are carefully designed to get you to say something that minimizes your injuries or suggests that you might be partially at fault. Something as simple as, "I'm doing okay," or "I didn't see them coming," can be taken out of context and used against you later. Then there's social media. Insurance companies actively monitor the profiles of people who file claims. A photo at a birthday party, a check-in at a restaurant, a post that says, "Feeling good today." None of those things mean you're not hurt. Having one decent day doesn't erase the rest of the week, but the insurance company will pull those posts and argue that your injuries just aren't as bad as that you claim. So don't give a recorded statement without talking to a lawyer first, and be extremely careful about what you post online while your case is open. The next one catches a lot of people off guard. Insurance companies will dig into your medical history looking for pre-existing condition. That means any prior injury, complaint, or treatment that could explain your current symptoms. If you had back pain before the accident, they'll argue the accident didn't cause it. If you saw a chiropractor years ago, they'll point to that and say that your pain was already there. Here's what you need to know. In Virginia, having a pre-existing condition does not disqualify you from recovering compensation. If the accident made an existing condition worse, that still counts. You're still entitled to be compensated for the additional harm. But the insurance company is counting on you not knowing that. They want you to hear pre-existing condition and just assume that your claim is dead, but it's not. The key is to be completely honest with your doctor about your full medical history, so your records accurately reflect what was there before the accident and what changed after it. And now the one that is unique to Virginia and the most dangerous of all. Virginia follows a rule called contributory negligence. In most states, if you are partially at fault for an accident, your compensation gets reduced by your percentage of fault. So if you were 10% at fault, you still get to recover 90%. Virginia doesn't work that way. Under contributory negligence, if the insurance company can prove you were even 1% at fault, they can deny your entire claim, not reduce it, deny it completely. This is one of the harshest rules in the country, and insurance companies in Virginia use it aggressively. Were you on your phone at the time of the crash? Were you going a few miles over the speed limit? Did you fail to use your turn signal? Any detail that suggests you contributed to the accident becomes their path to a complete denial. That's why what you say to the insurance company matters so much. And that's why having a lawyer who understands contributory negligence in Virginia is critical to protecting your claim. If you've been injured in Virginia and you feel like the insurance company is working against you rather than for you, that's because they are. Give us a call for a free consultation. You can reach us at 804-494-6908. We'll look at your claim, identify where you might be vulnerable, and help you protect your case from the tactics they use every single day. And you won't pay us a dime unless we recover money for you. If you want to keep learning how to protect yourself and your claim, make sure you watch our next video, because we're going to keep breaking down exactly what you need to know to get the full and fair compensation that you deserve.